Mr. Malaro, I do have Gary Bowerman.
Okay, can we take him, Judge? It shouldn't take long.
I can't hear you. I'm sorry.
Can we do him now? He shouldn't take very long.
That's why I said I have Gary Bowerman, if you want to take care of it.
Yes.
I have Mr. Sneed, so I think we have everybody we need. Hi, Mr. Bowerman. Go ahead and unmute your device.
Good morning, Ms. Anzalone. Good morning, Mr. Malaro. Good morning,
Good
Prosecutor.
morning. All right, so this is in the matter of the people of the state of Michigan versus Gary Scott Bowerman, file number 25-22277FH. I have Salvatore Malaro appearing on behalf of Mr. Bowerman, and I have Isaac Sneed appearing on behalf of the people today. This is the date and time scheduled for an arraignment in this matter. Mr. Malaro, you received a copy of the prosecutor's request for discovery and witness list.
Judge, we have received the information. We would waive its reading in open court. Waive any defects as time and place of service. We would acknowledge receipt of the witness list. I do not know if we've been served with a request for discovery. Mr. Bowerman would stand mute and ask that the court enter a not guilty plea. Judge, we would ask that a pretrial be set for next week. He has two other matters pending for pretrial next week on the 11th. And he is currently in a rehab facility.
And Mr. Bowerman's going to stay there, right?
Yes, Your Honor. I got this all done. Thank you.
No trips to Florida.
No, never. I plan to stay right where I'm at, if
Okay.
possible.
All right, so I will enter a plea of not guilty on his behalf. I will set all the matters for pretrial on June 11th. It's arraignment, so my staff will do the notice of hearing. I'm really proud of you, Mr. Bowerman. Stay where you are, and we'll see you back next Wednesday, all right?
I want to thank you guys all for giving this opportunity, and I promise you, my word is bond this time. I am staying, and thank you so much. I'll see you guys next week.
All right, thank you.
Have a good
Bye.
day.
Judge.
Bye-bye.
You too. All right. Dustin Evans is not here yet. Let's see what else you have. Right, I don't have a lot of people logging in yet, so hold on. Mr. Malaro. I don't know what this is. Olivia Stubbins Belson, could you unmute your device?
Okay. Yes, sorry about that.
Hi, what case are you here on?
I'm here for, do you need the case number or it's for
Yeah,
the
hold on one
Trent
second.
Berry?
All right, Ms. Stubbins Belson, I'm sorry. Hold on one second. All right, I'm
Okay.
sorry. This is Judge Anzalone, and I was wondering if I could see Trenton Berry, John Madison, and Jacinto Rodriguez.
Okay, I understood Barry and then it broke up.
John Madison and Jacinto Rodriguez.
Atlas said, which
Barry, Madison, and Rodriguez,
Yes, sir.
in that order?
Doesn't matter. But I'll take Barry first. All right.
Yes, ma'am.
Thank you.
You're welcome. Bye.
Okay. I'm sorry, Ms. Stubbins Belson. What case are you here on again?
I'm here for the Trenton Berry case.
Okay. So we're live on YouTube. So are you the attorney?
No, Your Honor, she's one of the victims represented.
Oh,
No.
got it. Okay. So ma'am, just go ahead and mute your device. And when we're done with the hearing, you can always just log off. All right.
Thank you, Judge.
Thank you. Mr. Malaro, I do have Mr. Winters or Mrs. Winters, but I'm assuming it's him on her device. All right, I have a device that says Jennifer Winters. I'm gonna assume that it's David Winters. And I've sent a request to unmute.
Judge, there's 2 winners on the docket.
Really? Oh, look, we have Jennifer Winters too. And that is Miss Dumont. All right, Miss Winters, I'm gonna change your screen name to reflect that Miss Dumont is your attorney, and she should be here shortly. And when she gets here, I'll bring you back in, okay?
Okay, no problem.
You don't have Mr. Winters with you too, do you?
Yes, I do. He's actually logging in now.
Oh, okay, so he's on a different device?
Yes, we didn't know if we could be on the same device or not.
As long as you don't have no contact, you can.
Oh, no, nothing like that.
Well, why don't you just let me see him then right now on your device?
Okay.
All right, thank you. And I'm gonna send a
problem.
request to start video too.
She said we could be on the same device.
I think you were last time. And who do I have in the jail? Mr. Barry?
Yes.
Okay, good. We'll be with you in just a second. Oh, Mr. Murphy, I didn't realize you were lurking there. You turned your video off and I forget about it. I'm sorry. All right, excellent. So now I have David Winters. Mr. Winters, can you hear me?
I can hear you.
Good. This is in the matter of the people of the state of Michigan versus David Winters, file number 25-22200FH. I have Salvatore Malaro appearing on behalf of Mr. Winters. And I have Isaac Sneed appearing on behalf of the people. This is the date and time set for a pretrial conference in this matter. Mr. Malaro, how would you like to proceed today?
Judge, I was under the impression this was Mr. McCready's case, Mr. Winters, so I was negotiating with the wrong prosecutor. So I would ask to adjourn this, and then we're gonna request a bench conference to see if this matter can get resolved.
All right, my next available pretrial is July 9 at 8:30 in the morning. And Mr. Malaro, can you do the step in order to adjourn? And Mr. Sneed, can you sign your name with permission?
Yes, thank you.
All right, so
That's fine,
Mr.
Judge.
Winters, we'll see you back on July 9 at 8:30 in the morning, same Zoom number. And make sure you reach out to your attorney in advance or return his calls, okay?
I sure will. Thank you.
All right, and Miss Winters, I'm just gonna put the phone in the waiting room now, and as soon as Ms. Demont shows up, I will take your case, all right?
Thank you.
All right, thank you. All right, so now I'm gonna pop you in the waiting room. All right, Trenton Berry. Okay. This is in the matter of the people of the state of Michigan versus Trenton Berry, file number 24-21813FC. I have Douglas Hartung and Alexander Bayonetto appearing on behalf of the people, and I have Salvatore Malaro and Matthew Murphy appearing on behalf of Mr. Berry. I have a May 13 of 2025 report from the Forensic Center on competency. Has that been admitted for the record?
Yes, not yet.
Okay, Mr. Malaro, you also received this competency report?
Yes, we did, Your Honor.
All right, and Mr. Hartung and well, do you stipulate to entry of this report?
We do, Your Honor.
And Mr. Malaro, do you stipulate to entry of this report?
Yes, we would stipulate to the entry of the report.
All right, so the report is dated May 13 of 2025 regarding competency to stand trial. The back of it. Looks like he was seen by Dr. Edward Rodriguez. Let me get going back here. And the report was submitted by Samantha Baker, licensed psychologist, for the Forensic Center. And the findings are that Mr. Berry, was an 18-year-old male referred for evaluation regarding competency to stand trial. They reviewed his prior records, school records and mental health issues, showing that Mr. Berry had been compliant with both psychotherapy and psychotropic medication, both prior to and following his arrest, received consistent treatment. There is an intellectual disability, and that is noted and evaluated in the records. During the evaluation interview, Mr. Berry demonstrated the ability to engage appropriately with logical thought processes and fair insight. His speech was linear and relevant throughout the interview. He knew who he was, where he was, the exact date, and understood the purpose of the interview. He appeared to be a low average intelligence. His emotional expression was relatively unremarkable. He was polite and cooperative with the interview and denied any current thoughts of suicide or self-harm. Mr. Berry was aware of the underlying allegations against him. He demonstrated an understanding of his current charges and the associated maximum penalties. He demonstrated capacity to discuss the allegations against him in an organized manner. He spoke at length about the roles of various persons and roles related to resolution in this case, including judge, defense attorney, prosecuting attorney, witnesses, defendant, and jury. He understood the implications and definitions of various pleas, including guilty, not guilty, no contest, and not guilty by reason of insanity, either following education or prior to receipt of such education. He understood the concepts of plea bargain and a trial and discussed these contents in the context of his current charges. He recognized the utility of working with his defense attorney despite his expressed concerns. He expressed a desire for a positive outcome, which to his case, which demonstrated self-interest and flexibility. And they end with, while I acknowledge that the ultimate decision in this matter rests upon a judicial determination, in response to the request of the court, it is my opinion that Mr. Berry was competent, is competent, and was competent to stand trial at the time of the evaluation. That is to say, he was capable of understanding the nature and object of the proceedings against him, as well as assisting rationally in his own defense. Anything to add, Mr. Hartung?
No, Your Honor, thank you.
Anything to add, Mr. Malaro?
No, Your Honor.
So I do have a finding and order on competency. I'm going to make a couple copies because I think they need like 5 originals. So we will make those copies. The court will find that the defendant is competent to stand trial. The case shall continue to the next stage of the criminal process. And at this time, are the parties requesting a pretrial date?
Judge, we'd request a trial date.
Okay. So, Ms. Adams, I'll put that finding in order on top of the report, and then I'll just need 4 copies.
Okay.
And Ms. Adams, would it be possible to get the book? Oh, thank you. No, everybody. Take this and bring this. Yeah. All right, hold on 1 second. Mr. Malaro, how many days do you think you need for trial?
I expect the defense to put on 2 to 3 days worth of testimony.
Mr. Hartung?
This was originally set for 2 full weeks of trial, including Monday,
Okay.
back when we had originally set the trial.
Okay, so second. Miss Adams, what does Monday, September 29th look like in the morning? Or, I'm sorry, yeah, September 29th.
Judge, I'm not available that week.
Thank you. All right, I have Monday, October 6th.
That's no good. That whole section's no good for me, Your Honor. Sorry.
Guys are like divorce attorneys. I can never schedule them. Now, for the record, our Mondays are scheduled out like 4 months and there'll be 40 cases scheduled on a Monday. So the best,
Yeah, I mean, do we have to start on Monday, Mr. Hartung?
We don't have to. You just said it that way before to get it through the 2 full weeks.
right. So we're not available September 30th that week, right, Mr. Malaro?
Yeah, I'll be out of the office that week.
You're not available October 7th.
That whole middle chunk of October is bad for me. End of October, 1st November would probably be better from my standpoint.
That's where I'm ending up. I'm sorry. So we're closed November 11th for Veterans Day. So we have a closure on that day. But if I go back to November 3rd, we would have, I could start a Monday trial date, but understanding we're closed for Veterans Day.
That's
So,
fine with us.
okay, so trial date starting November 3rd, November 3rd, hold on. Well, let's see here, November 3rd. No, because family law, no. When is family law institute? Oh, that would work. So 2 weeks starting November 3rd, Mr. Malaro?
Yeah, that's fine. That'd be perfect, actually.
Mr. Benetto
Yes, sir.
and Mr. Murphy?
Yes, that works for myself. Thank you, Your Honor.
All right, so the November 3rd of 25 at 9 a.m. Obviously, our trials start at 9 a.m. Except for Wednesdays, we start at 10:30 a.m. I'm going to, are you here October 24th, Mr. Hartung?
I'm sorry,
Are you in town October 24th?
I'm not all here by Zoom.
Well, I would like a day to sit down and do jury instructions with both of you, like have them submitted and then all of us sit down and finalize them before the trial. But I could do,
The 24th should be fine.
I could do Halloween, October
That's fine too.
31st. Mr. Malaro, you available October 31?
Yeah, says I am.
All right, so I'm gonna set final pre-trial for October 31. It's a Friday, so that's not my typical time at 8 a.m. And that'll be in person, so we can sit down and go through the already submitted jury instructions, because I'm going to require them to be submitted by October 24.
Your Honor, we already submitted ours quite some time ago.
Good,
And board year and witness list.
okay. Just in case there's any changes, I'll put another date on there, because that'll give you both an opportunity to make any changes if you need to. And I'll make that the final motion date too, on that Friday morning.
Is that filed and heard, Your Honor?
Always, yep. Let's see, today is June 4, 5. All right, so I have a scheduling order. Trial begin November 3rd of 2025 at 9 a.m. It's scheduled for 9 days, but obviously jury deliberations can go into the next week. Motion deadline filed and heard, and motion and limine deadline October 31. Obviously, you guys have had plenty of time. Any amended jury instructions or any jury instructions due October 24 of 25, as well as voir dire questions. There will be a final pretrial conference in person on Friday, October 31 at 8 a.m. Do you want Mr. Barry brought in person as well, Mr. Malaro?
For the final pretrial?
Yes, sir. I mean, you're
Sure,
gonna be
yeah,
in person. Okay, so I'll put that in twice in person, so maybe. All right, I have finished the scheduling order and we will get copies out to everybody. Is there anything else we need to address?
I have one thing. We don't have the witness list for the defense. It was scheduled to be delivered to us on February 12th. We had a bench conference in this court on February 11th. They said they had, at that time, they said they had their witness list prepared. They told us they would get it to us. They never have. On May 7th, I texted Mr. Malaro and said, I'd like to have your witness list so we can get our investigators to, interview anybody as necessary. And he said he would. Still haven't got it. It's been 28 days later now. Still don't have the witness list. It's kind of become a practice by the public defender's office not to give the prosecutors the witness list. And I don't understand why the courts continue to put up with that, because the court has issued an order. They have been required to do this. They don't follow these rules consistently as it relates to murder cases. I recall one recent case where I got the witness list 18 hours before the trial was set to start. And I guess the court felt that there was nothing they could do about it at that point in time. We don't want to risk an ineffective assistance of counsel argument, but we're all officers of the court here. And I think it's incumbent upon all of us to follow the court's rules.
Deadline of June 20th.
Fine.
Mr. Malaro, you can provide that by June 20th.
Sure. But to respond,
right.
Judge, I think I deserve to respond to that.
You can.
Likewise, our office gets reports, witness lists, amended witness lists, right up to the moment of trial. I don't think there's the insinuation here I resent, and Mr. Hartung knows better. There was a competency evaluation. Until we knew what that was, there's no point in doing this extra work on this matter. So it goes both ways.
You told me you had it already done and prepared.
All right. Thank you, gentlemen. We will see you back on October 31st for a final pretrial settlement conference. Thank you.
Thank you, Your Honor.
Ms. Demont,
Judge.
I have Ms. Winters. Let me take her real quick.
We ready?
And we got to be up here to be ready. Who's on this, Sarah, stop? Oh, you're the defendant, Mr. Johnson?
Yes.
Correct?
Yes.
Okay, and Langston Adams is your attorney,
Mm-hmm.
and the state's attorney is here. Earlier, you pleaded guilty to, I think it was just paragraph 1 of this indictment, right?
That's correct, Your Honor.
Which was third-degree felony, charging you with causing bodily injury to a disabled individual. And pre-sentence report has been prepared in this case. Have the parties had an opportunity to review it? And are there any corrections or changes to it, beginning with the state
No, Your Honor.
and defense?
No, Your Honor.
Then it is made part of the record for all purposes. All right, the agreement is whatever sentence shall not exceed a cap of 6 years imprisonment. So I think what we have here is several options. The defendant could be placed on deferred or unadjudicated probation for up to 10 years in length of probation. He could be found guilty, sentenced to no less than 2, no more than 6 years confinement in prison, and that could be suspended and he could be placed on probation. And finally, he could be sentenced to no less than 2, no more than 6 years confinement in prison. Those are about every option available in the Code of Criminal Procedure and the Penal Code. So is the defense ready?
Yes, Your Honor.
Go ahead.
Your Honor, with this particular case, what it really stems from, and I know you've read the police version of it, but let me give you a little bit more into that. This is his biological daughter. They've been having problems with her posting naked, nude images online. So that's a problem that he's been having with his biological daughter. And they've done things to address that, counseling, talking with her, working with her over and over and over again. Well, on this particular night in question, his current paramour, and she's to my right, and she has a hand up in the courtroom. As you can see, that lady is disabled. She's in a wheelchair, and my client is taking care of her. He's her support. He's everything. The biological daughter got mad at her for for disciplining that was taking place and actually hit her. Now, Judge, I remember a time, and I'm quite sure you do as well, when a child typically would not raise their hand to an adult. And I'm not justifying my client's actions, but when the child with a history with the promiscuity that was going on, and then the child assaults a disabled lady, my client did take her into I believe the adjoining room and discipline the child by spanking. Now, I'm not saying that the extent of the spanking was justified, because I'm quite sure many of us in this courtroom have been spanked. I mean, I remember myself when I was in high school, it was common for the coaches, assistant principals to give corporal punishment. And I'm quite sure even when you was in school, Judge, you dealt with corporal punishment to an extent. So I'm not saying that, the extent of the corporal punishment was justified, but the circumstances.
Well, what wasn't justified that you think?
The lashes and the body, the thing went too far. I mean, I know I've got corporal, and I'm quite sure you have too, but I haven't been hit like that. And
so you're saying something was wrong with that?
Yeah, no doubt about it. I'm not defending that. I'm saying something was wrong with that. But what I'm saying is
what was the defendant striking the little girl with?
I think it was a fishing rod.
A fishing rod.
Right. I think it was, and don't get me wrong, Judge. I mean, okay. I know in my day when the coach got us, it was a
fiberglass rod.
No, it was a powder. I got it, and
I'm quite sure you got a fiberglass rod here in this case.
Right. Absolutely right. Right. But I'm saying,
anybody want that? Anybody want to get struck by a fiberglass rod?
No, not at all. Not at all.
I'm not asking who would want to strike Rife, because everybody's hands would be raised. But all the defense bars raising their hand.
But I'm quite
talking about something else.
But I'm quite sure he got a paddle.
The point being is there's some disturbing facts.
Absolutely. And I want to deal with those, Judge. You absolutely right.
What's the child?
This is a teenage girl.
How old was the child at the time of this?
17 now.
She was 16, Your Honor.
Okay.
Yeah. So, Judge, like I say, I mean, I'm not defending the extent of it. I'm just saying the circumstances in which he lost a little bit of control.
Are there any photographs of the injuries?
There are, Your Honor, on a USB drive.
It states that she had lacerations and cuts on her back and upper right shoulder.
She was also missing a fingernail.
Say that again?
She was missing a fingernail.
Oh, well, I thought you said just finger. Fingernail? Did she lost a fingernail in this?
Now, my client is gonna say that had nothing. This fingernail had nothing to do with him. That's a separate. That had nothing to do with the spanking.
That's the least of my concerns on this. Yeah.
Right.
Let's put the fingernail out.
Right.
Let's just take that out of the equation.
Right.
It's still disturbing.
No, it's no doubt about it.
Okay.
And where I'm going with this, Judge, is that corporal punishment should not go to that extent. The only reason I just brought it up is that many of us in this courtroom have had corporal punishment. But what I was trying to say, Judge, is the circumstances of this is the little girl hit an adult, and the little girl had been posting nude pictures of herself, and the parent is reacting to that. And the extent that the parent reacted was a little bit, well, not a little, it was too far.
Okay.
So with that being the case, our argument for asking you to put him on deferred education is a twofold argument. The first argument, and I had Mrs. Whitmore as yeah, I'm sorry, Whitmere as a witness.
W.
Yes, as a witness, and she wanted to talk to you directly. I know she's in a wheelchair, she's not wheeled up, but what she's asking you for is just to have sympathy for her particularly. That's the caregiver. She's in a wheelchair. The only reason she's in court today is because he drove her here. I mean, if he was to be put in jail today, she doesn't even have a ride home. I mean, he's taking care of groceries, taking care of this, taking care of that, and she wants to talk to you directly.
So what's the point?
The point is that she's going to beg you to put him on probation and to have mercy on him, and that will be the point of her. And she wants to talk to you directly.
Okay. Well, but you're saying he needs to be put on probation so he can take care of her?
That's one. That is one.
Is that an important reason?
Well, for a lady that is not mobile, yes. For her, it's super important because she can't get around.
Okay. And do you feel as though that's necessary here in this circumstance?
Well, in this particular circumstance, why I was asking, in addition to that, is that he went too far in disciplining his child. But
we're talking about? I mean, the grand jury indicted, and apparently the defense is admitting liability here, culpability. The question is, what do we do, and what message do we send out?
And what I would suggest that you do is put him on the intensive supervision program, get him the anger management, order that he takes parenting classes, order that he takes the battery intervention classes, order him to take classes that help him to cope better with those circumstances. But at the end of the day, I think that this was a situation where he went over the edge because the little girl hit the disabled lady, and the little girl was posting naked pictures online. And I think as the father, he overreacted. I mean, that's the only way I can describe it. He overreacted in the discipline of her. Now, I'm not saying corporal punishment is bad. I got corporal punishment when I was young, and I'm quite sure you got it too. But
never did, but I can understand how you would get it regularly.
Well, you probably got it at school.
No, we all. I think we all.
Yeah.
Should. Everybody makes mistakes.
True.
And especially children have to learn from mistakes. And
right.
But how you deal with it? I never had a fishing rod slapped on me.
And I have
back and my buttocks. I've never had that. It's a deadly weapon because in the manner of its use, it can cause serious bodily injury.
That is correct, Judge. And that's why I'm not defending
it. That's a problem. That's the issue. That's the aggravating factor here.
Absolutely. And to address that, what he's telling me now is that I believe, in your bond orders, you have no contact with the victim. That's typically what you do.
Yeah.
When I talked to him before, he's telling me, now I'm only going by what he's telling us. He's telling me that he's not having contact with the girl. And with her being 17 years old and she's fitting to be an adult, at least according to what Mrs. Scott lives. You know where she lives. I don't know.
She lives
somewhere else.
She's with her grandmother.
She lives with the grandmother. So there's not going to be a danger to the child because he's not around her. And in one more year, she's going to be an adult, 18, doing whatever.
He's not a danger. He's not a danger to the child unless he gets around. That's the statement. I mean, I can order this. But
and he didn't defy your order by going around her, at least to my knowledge, and talking to him. And that's why I was asking, Judge, that if he gets that treatment, and I know your probation is high success, He's gonna be successful on that probation. He's not a danger to the child. And this was just a parent that just went over the edge with his little girl that was posting naked pictures online, and the little girl who hit a disabled person. The discipline went a little, well, it went too far, but to put him in jail for 6 years, I don't think is the solution to this. I think the solution is to get him the help with the classes, the treatments, the battle program, the anger management program, conflict resolution program, have him check in with you. And that's part of one of the reasons, I had talked to him about, and he wanted to do this cap because he knew that the cap would be totally in your hands. And I said, hey, talk to Judge Stevens, talk to him yourself. And he would be open. I can't tell you what he's gonna do, but he'll be open to what you gotta say. So I'll leave it with him. And she just wanted. And if you don't mind, Jess, she's in a wheelchair. Do you mind if she just says one word from there?
What is she gonna say? Yeah, we can't control outbursts, but what is she gonna say?
I anticipate that she's gonna beg you to allow him to have probation.
Is that right?
Yes.
Okay, that's conveyed to me. I
That's what
appreciate
I
and
anticipate
understand
that she's
the
gonna say.
Okay.
And then as far as him, I don't want to put any words into his mouth. I let him speak to you directly. Oh,
Let me ask, hold on. The defendant was convicted in 2014 of burglary of a home.
that's true.
What was the sentence?
4 years TDC.
What other criminal history does the defendant have?
He has quite a lengthy misdemeanor history, Your Honor, of possession and theft. And then he's got an unauthorized use of a motor vehicle that he got 1 year state jail for, the burglary of a habitation that he got 4 years for, the aggravated assault with a deadly weapon that he pled to a lesser and got 180 days state jail, and then the new injury to a child disabled.
Okay, so this is his fourth felony offense.
Yes, Your Honor.
Absolutely.
Fourth felony conviction, or not. It's fourth felony case that he's subject to sentencing on. Okay. And this goes back over for 30 years.
Mhm.
Misdemeanor is a 96 case.
Mhm.
And it doesn't go without notice that in 2018, it looks like he did 90 days in the county jail for assault of another person. So this isn't his first assault either.
No, he also had the aggravated assault in 2018.
It's his third assault.
And Judge, I'm not hiding from his past. His past speaks for itself. It's just in this particular incident, and I know his past you can't run from. His past is what it is. You got a little girl.
It's never in the past.
No,
It's
the current.
what the famous written saying is.
Right. And like I said, I'm not justifying his actions. I'm not trying to say that it was right. But what I am trying to say is you got your daughter posting pictures of herself online, and then that daughter strikes the stepmama. He overreacted to that.
Yeah, I wouldn't have gotten a deadly weapon and
No,
assaulted
you're
the
right.
child.
Yeah, I agree with you on
Okay,
that. You're
all
right.
right.
But that was the circumstances.
No, that's why we're here.
Right. Right. And that's why I was asking you to consider him for probation. It's those particular circumstances of this particular case. This is not one of those cases, because I do CPS cases too. I mean, it's not one of those cases where you got the parent who, for example, got the cigarette and torturing that child, or the parent that's not feeding the child. In this situation, you got the parent that was disciplining the child after the child had struck a disabled woman, and after the child was posting naked pictures online. And I think he went too far.
But it's the legislature cites it as a third-degree felony. It's
Yes,
not
sir.
the least serious type of felony either.
Yes, you absolutely
Third-degree
right.
felony where you can go up to 10 years in prison according to the legislature. So it is set forth in the law how important it is and where it places. And And the elements is because a child was
Correct.
on. And in this case, what's lucky is that I guess that a deadly weapon wasn't alleged in here. I don't know what difference that would really make, since being a child makes a aggravated crime, but well, it would have been aggravated assault. It's a different type of crime. Aggravated assault with using a deadly weapon could have easily been alleged, and it's a second-degree felony, more serious. But you can't harm a child in this way. Then children should be disciplined. That's how way they learn and correct behavior. Nobody's debating that. You just don't use a deadly weapon in the device with the device as the instrument to discipline someone. What state says?
Your Honor, the defense has really failed to mention what I think is a key part of this case, which is that the child has intellectual disabilities. Just because the child,
Tell me exactly in this case what we're talking about.
the child suffers from, she is mentally slow. She had a hard time talking to police. This is why it's a third-degree felony, was because of her intellectual
Does she go to a
disabilities.
special program in school? Does she attend a special program? Or
It was supposed to be. I don't know if she is now.
what about that, Langston? Do you know anything about that?
With your daughter, I'll, because he know better than me. Are you aware about any kind of intellectual? Because they're saying that she have, you address that. You can address that yourself. I mean, it's your kid. You know better than me.
With my daughter, I got her like February 22nd or February 28th of 2022. My daughter was
Say that again.
He said February
22nd or February 28th.
Of 2022.
The
What do you
2000.
mean you got your daughter?
You got
said
I got my daughter back.
He didn't have custody.
I never lost my rights, but she was in foster care. She was staying with a lady named Miss Ella Davis. She got put into foster care because she ended up on the second floor by herself at the age of 1 or 2. And I never.
Why is she in foster care?
She's not in foster care now.
Why was she in foster care?
Because her mother, she's a drug addict. She left her daughter with her mother, which her mother passed. She left my daughter with her mother, her grandmother, and my daughter ended up on second floor. And the neighbor, I found this out when I was working. The neighbor called and they ended up taking my daughter into CPS custody. But the lady didn't want to separate her from her brother and her sister. So she was with this lady for so long, since she was 1 and 2 years old. She was with this lady up until the age of 14. I didn't get my daughter to after that because my daughter, she did something to the lady. She cursed the lady out. She wilded out with the lady. So the lady sent her to her mother, but her mother was not supposed to have her because she don't have no rights over her. So I ended up getting her at that age of at the age of 14. I ended up getting her then, but when she was with the lady named Miss Ella Davis, she never told me that my daughter was like this. I never knew it myself. I thought she was just, normal. I never knew she had this problem or that problem or anything like that. I never knew none of that.
How old are you right now?
I'm 40. I just turned 47.
Go ahead.
So, and don't get me wrong, when she was in this foster care with this lady, I was making my duty to take the time out of my day when I was working to go spend time, check on her or getting to know her or whatever, because every person in school told her, they told her she didn't have no daddy. So that kind of broke her a little bit, but as me showing in my physical form, by me showing my face, by me letting her know that you got a daddy that loves you. You got a father that's gonna be there for you. But all this other stuff that's going on, I never knew none of it at all. Ain't nobody never told me that. They kept me in the blind. So I had to go off of what I know, and by learning her when she was with me, that's the only way I learned her.
So in summation, what you're saying is that if the state is suggesting that the child had some type of a mental issue or delayed issue as far as mind, whatever, and that was documented, that's something that you did not know about. So you responded.
I have no recollection.
You had no information about that. Is that right?
Yes, I have no recollection of it. I thought she was okay. I have no information on anything but her just being my daughter. That's the only thing I knew, and by me putting her in a government federal program, but she did the pornography on a federal government program. So the school called me and told me I need to check her computer.
Right.
I need to do this, or I'm gonna have federal charges on me. I can go to federal prison for what she did. I didn't understand. My daughter did this for age 14, 15, and 16.
Right, but your response to the state's question that was brought out is that if there's any documents that go to mental issues or whatever, you weren't aware of that.
I wasn't aware at all.
Anything else?
No, well, that's all I got, Judge. And like I say, he and his spouse that's here is basically begging for mercy from the court. And basically, you had a father who overreacted when the child punched her, and when the child was putting those naked photos online, and it was an overreaction. It shouldn't have taken her. Shouldn't have hit her with the rod. Injuries to her back should not have occurred. Many people get caught, like I have, like you and many people caught, but none of us got anything like that. And I know I've never got hit like that in my life. I've never had where I was bleeding, never in my life anything like that happened. But what I am saying for mitigation purposes is that he just overreacted as a dad. I mean, he went too far considering the circumstances in disciplining his child. And there's nothing that the state is saying to refute that this was about disciplining the child.
If I could, Your Honor, I can refute that. I just haven't had a chance to speak.
You'll get a chance. Anything else you want to know?
That's all I want to say.
Okay. By the way, the pre-sentence report had been tendered. Were there any corrections or changes to it?
No, yeah.
Other than that, then it's made a part of the record for all purposes for this sentencing. Okay, stay.
Your Honor, I would like to point out what the victim said about this case to police when she ran to a restaurant to ask for help because her father had beaten her 30 times with a fishing rod, is that they had believed that she had stolen some popcorn from a corner store. Not that she had assaulted her stepmother or that she had done anything with any pornographic videos, but that she had made popcorn and that he had saw a juice box in her room, and that's what caused him to beat her. When officers responded to the medical center, they estimated that he hit her 30 different times with that fishing rod. This was not corporal punishment. This was abuse. This was torture. And then in his statement to probation, he said, "I'm upset and disappointed from what my daughter has put me through." Not any remorse for anything that he did to his own child, his own disabled child. He wants to have probation to help another disabled person when this is his 4th assault case and it's his 4th felony offense. I see no reason why we wouldn't give him any less than 6 years confinement.
Anything, any summary you want to make?
Well,
or response?
What a quick response is that we said it was discipline for assaulting a disabled person. The state said it was discipline for something with food or what have you. But at the end of the day, this was discipline, and she can testify if you want her to that she was hit. She's in the courtroom. If there's any doubt that this child hit an adult, the person that was hit in the courtroom, I said, Judge, you can ask her right now. She's here. She'll tell you she was hit. I mean, you're looking at her. So, I mean, she's available. There's no doubt that this child punched an adult disabled lady who's in the courtroom. And like I said, he overreacted. He shouldn't have gone to the point that he went to, but this was about disciplining this child for the pornography and for the assault. And that's why we asking you, Judge. I don't think that he's gonna leave this courtroom and be a danger to anybody, go break the laws or go do anything like that. He just want to take care of his wife, who he drove up here today. And matter of fact, if he went to jail this very second, I don't even know how she would even get home. I mean, I don't know. I mean, I don't even know how she would even get home. He's been doing a good job with taking care of her. And I told him, I said, hey, I don't know what's gonna happen. It's a cap of 6 years. The judge will give you deferred. He can put you in jail for 6 years. He can give you 2 years, 3. I told him, I said, I don't know. I say, but at least one thing for certain, whatever it is, Judge Stevens is gonna be fair. Talk to him and just make your case to him. And I'll close with him. Is there anything you want to tell Judge Stevens that I left out?
Before things seem to be right, this is, I don't want to be there for her because she needs me any regardless, you know. I'm the only one that's there to do what I need to do for her. I'm not too much worried about me. It's just her. I gotta get her out the bed, help her out the bed, help her in the shower. I got to do all that. And she can't, it's hard. She done failed over 5 times. 5. Because she been through so much with the person she used to be with before. And it really made it bad for her. She's wired up on her right side. It's hard for her to walk. I got to cook. I wash clothes. She don't do nothing. I do everything that's possible that I need to do for her.
All right, I'm going to ask you just a couple of questions. How many misdemeanor convictions do you have? I mean, it's your life. No one would know better than you.
Three, four, I'm not sure.
3 or 4, you think?
It's been so long. I don't keep up with it.
It was as recent as 2018. But you were 3 or 4?
Yeah, I think it's 3 or 4. I'm not
10. 10. There are 10 of them. And let's see. Most of them drug offenses, and then there's assault causing bodily injury was the last. What about felony offenses? How many felony convictions do you have? See how close you are to the correct answer, guessing your life's history.
Possession, weapon, burglary, habitation.
What does that say that you don't even know the answer? What does that say about you? I tell you how many I have. I mean, that would be an impact in me because that should be a major part of your life. But
I think I got about 4, Judge.
I have 3 and then this one. So 3 convictions. But the point is that that's 13 convictions in courts of law, non-Class C misdemeanors and courts of record. But that's far too many for anyone. But there's so many you can't even remember. And in this case, the defense, you don't give a lot for your attorney to help you on in these circumstances because nobody finds injuries to a child amusing, much less appropriate. It's completely and totally uncalled for. Yes, they need to be disciplined, but you don't take a deadly weapon like a fiberglass fishing rod and beat the child with who ended up with, let's see, multiple welts, obvious welts on her back, both arms, backside of her legs, bleeding, swelling, and redness of her injuries. Nobody feels sorry for you. Nobody feels sorry for you. And you've said in your whole set of defense and statements here, the motivation was her actions, her actions. The pre-sentence report that's in evidence. You're 45 years old, 44? Yeah. You were a daily synthetic marijuana user for over a decade until just a few years ago, according to you. Synthetic marijuana makes anybody out of their mind. So that's the role modeling that child had to deal with from you. Multiple years of synthetic marijuana, cocaine, weekly cocaine use for 8 years until you were 30. You admitted using LSD, ecstasy, marijuana monthly since you were 18 years old until a month ago, according to the pre-sentence report. Diagnosed with depression, symptoms of anxiety, attempted suicide. You participated in patient treatment for mental issues at Ben Taub. What kind of role modeling is that for the poor child? I have children, and they're going to emulate what their parents' examples are. At the very least, you get poor parenting of the year. You're a terrible parent. And so it's the child's fault that she wasn't acting appropriate? And so you beat her? You've got to see how bizarre that is and how missed of the mark you are. You've got it backwards. You're responsible. Yes. I feel sorry for the child. The child really didn't have much of a chance because role modeling is the most important influence on a child from the parents. Yeah, and now you're saying you want to do something that is humane for the lady that you're taking care of, you're living with, and that's your get out of jail free card. You can assault a child after all these years and years of abuse to yourself as well as to the child. And then you want to be able to say, I got to get out of jail free card. I got to take care of somebody. Now you are practicing humanitarianism. You hadn't done it to your own child. Your own child doesn't get it. Your own blood. My goodness. Why would you be so worried about someone else? The Creator gave you the child. You chose a partner, which is okay. But how did you do with what gift the Creator gave to you? You abused the child and self-abused yourself with narcotics years and years and years and years, which didn't give the child any hope or role modeling opportunity to make wise choices. This all explained. All right. Yeah, you were in jail for 7 days here in this, according to this record. in accordance with this case. When you were in jail, who was taking care of the lady?
No, there was nobody there.
So she's able to take care of herself when you're in jail. Well, there she is, and you were in jail for 7 days. How did she survive?
My neighbor came and checked on her. But my neighbor works, so my neighbor was able to check on her or whatever. But when she needed somebody to check
All
on
right.
her.
Okay.
So I had to have my neighbor to check on her.
If nothing further, the court's going to find the defendant has pleaded guilty here to this third-degree felony of injury to a child. Voluntarily, knowingly, intelligently, there was sufficient evidence supporting the guilty plea to find you guilty beyond a reason, based upon State's Exhibit 1 that was introduced into evidence. I now find you guilty beyond a reasonable doubt of this third-degree felony of injury to a child. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 6 years. That is one of the options that the court has. I want that just to sink in for just a moment. So you go prison for 6 years. Your paramour, the lady you're taking care of, she's stuck without anybody to take care of. The child, father's in prison again. And then all you're doing is making a mess. Another chapter in the same book of here I am making a mess. The court's going to do this. Okay, I'm going to suspend the 6 years, place you on probation for 10 years. There will be terms and conditions of probation that you sorely need for dealing with other humans, as well as your family that you seem to disrespect and not have a humane attention in dealing with. Here's the probation orders. There needs to be some kind of program that moral recognition therapy, some comes into mind. Parenting class comes to mind, which you've wisely, the probation has already offered to place in here. Mental health services through Spindletop, enter in successfully completing the battering intervention and prevention program. You're going to submit to a substance abuse assessment because it's hard to believe anyone with years and years and years of chronic abuse to drugs telling us the truth and being forthright. Seldom does that ever happen. And there will be other terms and conditions of probation which you need to follow, which ironically are in your best interest and to help you be a better person. Why you haven't done this yourself. And you had to come into this court as a defendant assaulting your child, for strangers to have to fix the mess in your life is inexcusable, but it happens all the time in here. That's what we do. That's not all. When you harm a child, it goes with a price. You're going to serve 180 days in the county jail, and we'll do that on weekends. You're going to have to work some way to have this lady taken care of. But you don't avoid responsibility and punishment that's due by using the helplessness of others. Like, she didn't have anybody to take care of. You got to figure that somebody's got to help her for those. report on or before 6 o'clock p.m. each Friday. It will release you on 6 o'clock on Sunday, and you'll do that until 180 days are served. Do you understand? That's the price that this court sets because children should not be harmed, especially tortured. And then if you have the tendency that 180 days. All right. You understand what has happened today, so. Yes. This is what is called justice. It's, this court deems it to be the appropriate method, and it has its seriousness for the consequences and the circumstances of the harm to children and your self-harm that you have performed on yourself by not respecting yourself, by abusing drugs and committing so many offenses. You need to fix all of that while you're still alive. Anything else?
I don't have anything. I have something, Your Honor.
Yes,
When does the jail time begin?
it's Friday.
This Friday.
Mhm. So you've got 48 hours to figure out a care method for the loan. For those 2 days, do you understand? Anything else? Please see the probation officer.
Thank you, Your Honor.
Tara, off time.
To be on your town, but we'll be back.
You anxious to go next after that?
Oh, yeah.
24577 is called the state of Texas versus Tara. Is it Devanana?
Devana. It's spelled really weird. You can pronounce it Devanana or.
There's a
Devana.
syllable in there that's not being stated.
My brother's name is Micah Devin. And so my mom decided it would be cheeky to go with Devin Anna, but that's just a mouthful. So we just always say Devana.
Yeah, that's 4 syllables.
Yeah.
And your last name is Hoffdauer. You were here with Mr. Dusler, your attorney, and the state's attorney does the defendant. We have a formal reading of the indictment and arraignment here. Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about February 12th, 2024, in Jefferson County, Texas, you committed the second-degree felony of assault on a peace officer by kicking the complainant. Do you understand what you're charged with here?
Yes, sir.
Second-degree felony.
No, Judge, she's completed lesser included.
That's correct, Judge.
Okay. It was second-degree felony was checked, but we missed the box completely. But
That's tablets for really active. It's
What is it, Class A?
Class A misdemeanor.
Okay. We'll write this in.
I did the best I did. It was just.
He did. I wrote over it trying to add in the fine, Judge, and I can
Okay.
confirm that tablets are fine.
You understand you're charged here with the indictment of a second-degree felony of assault on a peace officer. You understand that? Yes, begin.
Sorry.
There's an agreement that's been reached where you would be pleading guilty to the lesser included Class A misdemeanor of assault, which is within the elements of this indictment where it is alleged you intentionally, knowingly, and recklessly caused bodily injury to another person. That constitutes, if found true, a Class A misdemeanor. which carries with it.
It's horrible, Judge. Sorry.
I'm gonna rewrite the punishment range because
It won't even allow us to erase to be able to clean it up, Judge.
mine, when I write, it's about 2 seconds later it shows up.
It was the ghost writing that
Thank
caused
you
it.
for that. Yes, okay. Which carries with it up to 1 year county jail and or up to $4,000 fine. The other side, do you understand the punishment range for Class A misdemeanor?
Yes.
An agreement's been reached in your case where you would be pleading guilty and placed on deferred or unadjudicated probation, which will be up to 1 year. And you will be fined $200, and there will be terms and conditions of probation, normal and customary for Class A misdemeanor assaults. Is that your understanding of the plan?
Yes, sir.
If I follow this, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this lesser included Class A misdemeanor? Guilty or not guilty?
Yes.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir. Yes.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Or the contents are true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence without objection. Among other things, the state you are mentally competent to enter your guilty plea, and it's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses, such as the one you have pleaded guilty to today, the Class A misdemeanor of assault. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is to a state, so help you God. And the court makes findings in accordance with this State's Exhibit 1. Is all of this true?
Yes, sir.
State's Exhibit 1, part of the record for all purposes, pre-sentence reports.
Yes, sir.
I'm going to follow this agreement and find that there is sufficient evidence supporting this guilty plea to find you guilty beyond a reasonable doubt of the lesser included offense of Class A misdemeanor of assault. And I'm following this agreement, and you are not going to be found guilty, but any finding of guilt will be deferred. You will be placed on deferred or unadjudicated probation for 1 year. There will be a fine of $200, and there will be other terms and conditions of probation, which are normal and customary for this type of offense. Please make sure you follow it. If you fail, your probation could be revoked and you could be sentenced up to a year in jail. You know, okay, good. I'm certain
She's never she has nothing on the record besides this, Judge. We'll move on to her.
There's always a first. Question is, will there be a second? Let's fix that. Okay.
Worked very hard to change my life.
All right, good for you. Please see the probation officer.
My purse. Thank you.
Good luck to you.
They got all that notes over there. Is that you?
Falls here on dust.
It's coming. They say, and it's not good. It's gonna sting a little. It's gonna cause people to have problems.
Yep.
Okay, that one. Did you want to stop?
These tablets are.
And I know it's Jacoby Manuel. And this is cause number 24CR2329. What are we doing?
He says that he's not guilty. He's in trial. And he'd also like it to be resolved as soon as possible, so he's asking for declaration.
The offer was a deferred probation.
But where's this vehicle now?
He has it. He owns the vehicle. It's his.
Y'all have a title on this? Does the state have a title in the victim's name? It says it is. Paid cash, signed the title, provided it to
Yes, I
Dixon.
think, yeah, we do. It's this guy's signatures on the back of the title. It was identified by his distinctive laptop, which for the record, I noticed when he approached the benching work today.
What's the date on the title?
Yeah. Three, 8/24.
It's his car, you say?
That's what he tells me.
Where's the title? Do you have a title for it? Where's the title to it? That's what counts in the state of Texas. Do y'all have a title you can produce?
So yeah,
Yeah, well, have a title for the car?
yeah, I do have the title.
Where is it?
It's in the vehicle.
Go get it.
I don't have the vehicle here to have to bring it. But I also had so it was two different titles. I had one in my car and I had another. So I had two titles to the vehicle because I thought I lost the person. But due to the fact that the man, I don't even know who this guy is that's accusing me of $4,000 because he never gave me $4,000. I have no idea who he is. But my brother had my car in the process, so I had let my brother borrow my car, but no guys gave me $4,000 for a car. That I have no.
No, a title is what dictates it, and signatures have a distinct similarity to that's what counts.
I mean, if
this is know this person, do you even know this guy?
I don't know him. I don't.
Okay.
So, okay. Well, I mean, if they want a trial, they get a trial. But I mean, if they would provide me some of this information, I might be able to look at this. But I mean, no one said anything to me. I gave them an offer and they rejected it, and now it's set for trial.
Yeah. Are you able to hire a lawyer?
I can't afford.
Why not?
Because the reason why
they're expensive, but the taxpayers, I don't want to pay for a mess that the grand jury says you caused. It's a presumption of innocence, but still, I'm not gonna pay for with my tax money. I don't want to. And that's what the people who put me in office say too. We're not gonna just freeload people who are charged with crimes because there's an investigation that's done and a grand jury does. And procedures are used to make sure that any person charged with a crime, it's not done frivolously. It's done responsibly, deliberately. And then that's your problem when you're charged with a crime to pay for the amount. I'm sorry. You don't have a job at all?
Yeah, I just started working a job, but I can't, I barely can afford my bills. I'm only in Bowman.
You just have to have less bills.
I'm only in Bowman right now. I was in Katy, so I'm only in Bowman. To this case, and once this
What do you
case is
do?
finished.
What is your job?
So I just work at I work at Home Outlet.
A what?
It's like a store like where you can cabinets and things like that.
Well, you have tax returns, right? You file tax returns every year?
I just started working. I haven't filed the tax return. So last year I didn't have a job.
When was the last time you filed a tax return?
2 years ago.
Oh, okay. Where were you working then?
I was working in Katy when I was still out of here.
I'm sorry. What were you doing?
Oh, I was a supervisor at Rock Distribution Center.
Like, what was your income then?
I had pretty decent income. I was about 65,000 a year.
Well, this is resolvable because of the methodology that is required in having registration and titles. And I'm going to reset this a couple of weeks for review. Why don't y'all see if y'all can get that, whatever it is, to the DA's office so that they can have a decision of whether they go forward or not. If you have a title and it's a worthy title, that's what counts. But if you don't, the state says they've got a title that has the signatures that are similar, that represent you and somebody else. And I mean, I don't see what the fact issues is on that unless somebody forged somebody's name with their using their handwriting, which is not easy.
Right. Either there's a crime here or a crime in the forgery of the title. I mean, one has to be true.
Something is just, if there's no other title. And if there is another title, there shouldn't be two titles.
And I was never paid any, absolutely no penny, absolutely nothing. So I can't sell my car and not get paid for my car.
Yes, sir. Okay. Well, let's get the title and let's figure out and get it over to the DA's office so that they can try to resolve this. Okay. Where's the vehicle right now?
It's on pinchback. It's not even much operable right now. But it's in my possession. Yes, sir. Yes, sir.
Okay. All right. All right. 2 weeks. Okay. Thanks. I'll be back and get some dissolve, get out, sign a reset. Let me see. But in jury for something.
Submitted a dismissal on or I'm sorry,
LD Mahone?
Yes.
But Dante Mahone.
Dante Mahone. Yes, they provided me.
Dismissed.
Probably next week.
I have Willie Cowart.
Yes, Your Honor, he's my cousin.
Yeah.
Where's Mr. Cowart?
He's in custody.
What is this?
Probation, Judge.
Okay, we're gonna have a hearing on it?
I think so. Judge.
Okay, well, let me get this other stuff out of the way, okay, and then we can get back to that. What are we gonna do on Dante Mahone? Okay.
Dante Mahone, which case was just dismissed.
Tell everyone.
You're right. I thought that was the familiar name.
About the day.
Ernest Thomas, 2 cases.
Ernest Thomas is president.
What are we going to do? There's an announcement, obstruction or retaliation, sex offender registration failure.
was indicted on a new case. I don't think Mr. Grove has discovery on that one.
I don't know about the new case. I discussed it with Mr. Thomas today, and Mr. Thomas
Here's my home.
Mr. Thomas is not guilty of these cases. Now, the new case, which I'm not aware of, I can't really comment on what.
It was a surprise thing. I never been to jail, so it's just a warrant popped up.
So does he have a warrant now?
No, I'm hoping I don't want to.
Well,
Well, this one's, look, the failure to comply with sex offender registration is cut and dry. Either, what is it showing for his registration? I mean, if there's, y'all have anything? I mean, he's not guilty, but he's supposed to be registering. There's got to,
Yes, sir.
there has to be proof of registration for this because he is required.
I've been arrested, sir. You haven't
he's
seen me.
registered in Louisiana. Is that correct?
I'm arrested here.
Registered here.
Where's your certificate or proof of
You
registration?
had Mr. Hamlin computer last time, remember?
I don't. I've got 5,000 cases.
All
I
right.
don't remember.
Yeah, I'm arrested.
Truly, I really don't. That's for y'all.
I've been arrested ever since I born out. Once y'all came got me from Louisiana. I've been arrested ever since then. I arrested every year on my birthday.
From Louisiana?
No, here. So this December coming, I got arrested again.
So what's the date? This is October 27th of 2022 is when you
Yes, sir.
failed. That was going on 3 years now.
And
That's the question on or about October 27th, 2022. Did you fail to register? Even though that's almost 3 years ago. I don't know.
That whole time, I was in Louisiana. I just got
It doesn't matter. Were you failing? Beaumont says you were supposed to be registering to them. Do you have some kind of registration in Louisiana you have to perform?
I'm not under them no more. That's what I'm saying. But when I didn't go register down there,
Oh, no, yes.
well, back in
I just got out of
2020,
jail for it in Louisiana.
back in 2022, you were required to register in Louisiana. When you were registered then even though that's 3 years ago, Judge. I believe that's the deal. And we go back and forth. He also has been in Orange County, I believe, but different registrations.
It says, the probable cause says the defendant had been living in Beaumont since February of 2022 and had not checked in for his annual verification of change in status as required by the Texas Code of Criminal Procedure.
Right, so he had deregistered in 2014 and said he was moving to Louisiana. And then we were alerted that he had been arrested in some misdemeanor offenses here in Beaumont and was providing an address that he was living at in Beaumont on Magnolia Street.
3438.
Right, and so that was what prompted the initiation of this case and investigation.
Now you see what happened with that was in 22. I was working in the hurricane in New Orleans. I came here on the weekend and got in that trouble. That's what had happened. But I was working in New Orleans. I got proof of it.
But you registered in Louisiana.
Louisiana, that's what I'm saying.
I think
And then when I failed to pay them, they got me for not registering because they was stealing money from me. Steady every 3 months, I was paying them $60. And when I found out I was supposed to be paying them $60 once a year, I just stopped going. And that's when they came with the failure to arrest. And that's when they picked me up. I was locked up in Orange County. Louisiana come got me from there. Then Texas come got me from Louisiana once I finished with Louisiana. And when I got out of jail here, I bonded out of jail here. I went downtown Beaumont and I registered.
So Judge, I'm going to add Mr. Grove to the discovery in Mr. Thomas's new case. I would suggest that they have some time to look at the discovery in that case, and then we can all come back.
Okay,
here in
now
weeks.
we've got another case that was indicted in March. Which states that on or about February 15th, that you committed the 3rd-degree felony of obstruction or retaliation.
And you're on, I didn't retaliate.
This isn't a debate. It's what the indictment reads, the grand jury indicted you for that. That's what I'm telling you, which carries with it up to 10 years in prison. But
So I'm,
what, are you living in Beaumont or not?
That's what it is, 1385 Fairway. I'm registered in Beaumont. I live 1385 Fairway, Beaumont, Texas.
I can follow up with the registered registration detective here in Beaumont and see if there's any validity to all this timeline. But either way, they're going to need time to look
You
at
have
the
a
new
driver's
discovery.
license?
No, sir.
Let me see it. What do you have? So you're driving a car?
No, I ain't driving no car.
What identification do you have?
Only thing I got in here is
What?
all right, the reason why I ain't got.
No, I don't want, I
No,
just
I'm
want
saying I got
to,
mine.
everybody has identification.
No, I got mine. Well, I was with it. But this while here, I
Oh, you
carry,
carry around, you don't carry around any identification?
my car just got in a wreck, sir. And I
So
still have
you
my-
ought to have your
I-
car.
Yeah.
You're driving a car?
No, the car I've been in, because my sister let me use it to go to work.
You're driving a car.
Yes, sir.
Well, you have to have a driver's license. Where's the driver?
Well,
Where's your
saying-
Texas motor
all right.
vehicle?
Is it-
Don't interrupt me. My question is, where is your Texas motor vehicle driver's license so that you can drive the car that you're saying you're driving to and from work?
I don't got no.
You don't have it. That's a crime. I mean, the rules don't apply to you, but they apply to everybody else? So you're not gonna trick me and try to take my wallet and flim-flam me. I mean, it didn't take long to figure out you're not following the rules here. That's why you got 2 indictments. Oh, I'm not guilty of anything. You can't, you've already admitted to operating a motor vehicle. You don't have a driver's license. That's a crime. Anything else you want to add?
All right, I got a license, but the license that I have.
Oh,
in my
now
car-
you have a
no,
driver's license.
It's just like I ain't got none because
All
All right.
You've said enough.
it's hard for them. All right.
You've said
It's hard
enough.
for them to switch it from Louisiana to here.
It's always
because-
somebody else's excuse.
Well, I
I
have-
just asked you, do you have a driver's license? You said no.
But it's not.
Now
Texas.
you don't, now you do.
Okay.
It just
But it's
miraculously
still not
appeared.
with me. It's in the red car in Nils. I'm supposed to go there today. I thought.
Why did you say you didn't have a
And get out.
driver's license a minute ago?
Because if you gonna want a Texas one, I don't have no Texas one. You on?
Sit over there.
Louisiana one?
Sit over there.
Yes, sir. I do got Louisiana.
I'll tell you. Sit over there. We'll deal with you later. What's his bond? You don't lie to me like that. What's his bond? We're gonna change that. Brittany, what are we gonna do on William Walker? Where'd she go? Okay, well, where's Rife?
Right, had to go to another court, but case needs to be reset because there's a new drug case.
Don, what are you gonna do?
I don't know, you need to reset and go over everything. It's kind of that new case, it's only
On,
about 2 months.
on Charles Johnson?
Yes, he's
Where's
right.
Mr. Johnson? Come on up. You're Charles Johnson? You're charged with the 2nd-degree felony of burglary of habitation. Mr. West is your attorney. What are we gonna do today?
Oh, need about 4 weeks reset.
Got 4 weeks. Get a resetting. Thank you. And Rife went somewhere and Brittany went somewhere.
Rife said he was going to need a reset on his. They have a new drug case that just got indicted. So he's
Here.
going to need, yes, sir. So he's going to need more time anyway.
Who's his lawyer? Who's his lawyer? He needs one. Sheena Miller, come on out. And in 24 CR 2453, you're charged with the state jail felony of, it's like, unlawfully acquiring a copper.
Yeah.
And that carries with it up to 2 years in the state jail. Your attorney, Mr. Kimler, we're gonna reset that 3 weeks. You need some more time for something. And did you say there was another case coming?
Yes, sir. I think Mr. Kimler was just aware of it recently that she got indicted on some new case.
No,
We're waiting on that.
Oh, I'm sorry. That's what it was.
How long do you think that'll, it's a drug
Yes, sir.
matter?
Yes.
Okay, well,
It's
they're
been
gonna
since,
test it to see what the drugs
the case
may
was
be.
on October 24, so.
It's the same
hopefully
deal.
they'll
All right,
get their credit.
okay.
Out of the same arrest?
Yeah.
Okay, so it's out of the same arrest, is what they're,
Reset for three weeks, okay? Get a resetting.
Wait,
Thank you.
which one?
Get a resetting.
both of them.
Both cases are reset. Yeah, we're not gonna handle one, we're not gonna do one in an installment and keep the other one. We're gonna work them together, so
Okay. Okay.
just get a setting. Brittany, come on out. Thank you. On William Walker.
Yes, he's in custody.
Mr. Walker.
Yeah, there you go.
He's in 2 years to the judge.
Mr. Walker,
Okay, I don't have any papers yet.
raise your right hand. These were arms are another ear, the haters, and other stuff like that. Your right document. Where's it, right there? Yeah, one more time, I need it much darker than that, I'm not scanning this. Okay, where's it right there? Okay, you can go stand in front of the judge.
Come forward, please. 23 CR 2056 is called. You were William O'Neill Walker. With Ms. Holmes, your attorney, and the state's attorney does the defendant waive a formal reading of the indictment and arraignment here. Can we proceed in summary?
Yes, you.
In summary, sir, this indictment alleges that on or about October 31st, 2022 in Jefferson County, Texas, you committed the second-degree felony of aggravated assault with a deadly weapon, namely a motor vehicle. Do you understand? Or an automobile? Do you understand what you're charged with here?
Yes, sir.
If convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached in your case where you would be pleading guilty and sentenced to 2 years in prison, and you would be given credit for all time served. Is that your understanding of the agreement?
Yes, sir.
By follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
Is there any restitution here?
No, Your Honor.
Says cause bodily injury to somebody else by ramming.
Your Honor, if you recall,
I don't remember.
this is one where the complainant is his wife. They actually got married after this incident occurred.
Oh, the complainant is this man's wife now?
Yes.
This that occurred during courting?
Yes, they got married after then this charge was indicted.
I can understand why they would want to get married since they're gonna be charged with aggravated assault to the child, to the lady. That was never my method of trying to ingratiate myself to a date by assaulting them. I never thought that was the right way.
Sorry.
The right way to court and, yeah.
Yes.
Okay. Did y'all get married, ceremonial?
Yes, sir.
With JP or a priest or somebody?
No, sir. It was in the court.
Who did it?
A judge in Mississippi.
A judge in Mississippi. Well, I'm sure they do the same thing. I mean, then you go through a formality of pledging your love and devotion to the other person. Did y'all do that?
Yes, sir.
What happened here? This isn't the way. That's not the way. You understand? I guess here you are. You are accepting responsibility. You made a mistake, but you understand. If you have a composure problem, the last person you're supposed to harm is somebody you pledge your love to, right?
Yes, sir.
Okay, is that fixed?
Yes, sir.
Okay, you're devoted to this lady?
Yes, sir.
Promise?
Yes, sir.
Forever and ever?
Yes, sir.
That's what they probably said, words to that effect. Then do you show love to this person every day?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
I'm going to show you what's marked as State's Exhibit 1 here. Did you sign that document? Voluntarily, understand
sir.
it. Discuss it with your attorney. Is everything true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection admitted. Among other things, the state you are mentally competent to enter your guilty plea is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of this crime and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You are totally satisfied with the representation provided by your lawyer. All of this is true, so help you God.
Yes, sir.
State's Exhibit 1 made a part of the record for all purposes. Your sentence report as well.
Yes, sir.
All right, I'm going to follow this agreement and find there is sufficient evidence supporting your guilty plea as you have entered your plea voluntarily, knowingly, intelligently from State's Exhibit 1 here. That is enough to support your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this second-degree felony of aggravated assault with a deadly weapon, namely an automobile. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice prison for a term of 2 years, the minimum. You will be given credit for all time you have served in connection with this offense. The judgment must reflect a deadly weapon, namely an automobile, was used in the commission of this offense as indicted in this case. I don't know how many thousands of cases I've resolved and presided over here in this job, 18 and a half years. This is a first to sentence a defendant for assaulting a person who later he marries. And it's possible that this could happen. But the point is you're capable of making mistakes like we all are. This is just a very disturbing one because a 4,000-pound metal missile can do a lot of damage to a human body. Somehow y'all must have fixed all of this and then fallen in love and now you're married. But hopefully this is far behind you.
Yes, sir.
And distances you from the future because you're supposed to treat that person with respect, with love, with compassion. Do you?
Yes, sir.
Well, and Your Honor, I believe she had filed for divorce, but they did get married after this, after the incident. That was when they.
Okay. So y'all are in the process of a divorce now?
I'm not sure if he's been served with that or not, but that's just my understanding.
Well, does the lady see you? Do you communicate with her regularly?
I directed him to stop communicating until we got this resolved.
Okay, well, if y'all can work this out. I want people to be happy, but most importantly, to understand what is a relationship that you profess love for. And love is not harm has nothing to do with love. It's completely opposite. And respect. That's part of a proper relationship. And that has to be displayed 24 hours a day for a relationship to work properly. All right. Anything else?
No, Your Honor, thank you.
Thank you. Okay. Back to Ernest Thomas. Is that right? You know what? This thing showed power failure.
We need a new one.
We're back here. And hey, what have we been doing, Willie Coward?
Willie Cowart's a hearing judge.
Okay, okay.
There's some strange facts, background on that, but it is a
Welcome.
hearing.
Welcome to every case in this room.
Oh, yes, sir.
If you would ask Mr. Thomas is on the failure to register case, his bond is $15,000. And on the obstruction or retaliation case, it's $8,500.
Okay.
And Judge, Mr. Eckhart said that he would give me discovery in the new case, but I don't have discovery in that case, although I do the dated register case.
All right, what, let's deal with that. That's to me, the issue, the defendant, whether he failed in the past, as reflected in the indictment to register, that's one issue that really isn't timely right now. The question is, no one posts a bond. The bond, the first element of requirements of bond is don't commit a crime. Every moment he has failed to comply with sex offender registration is a crime. And I want to know, what proof is it that supports, after what I've heard here, that supports he has complied with sex offender registration? Until I can see that, his bond is full. He stays in jail. So you're not going to continue to, you have a continuing duty, according to the information this court has, to comply with bond, comply with sex offender registration. And you're not walking out of this room without proof that you are complying at this time.
Judge, I think that when he made bond in that sex offender registration case, that from that point forward, he was properly registered in Beaumont.
Just to give him a birthday, do something.
So I think since he's made bond in that case, he has properly registered here where he's been living.
Okay, the state's comfortable with the information you have that supports that statement, or you wouldn't have made it.
Yes.
And we're talking 2014, I believe.
It doesn't matter, David. He has a continuing duty.
Yes, sir. I understand.
But after talking to him, the message I got, the information I got after English language here, was he wasn't registered. You have to carry around proof of it when it's asked of you.
Yes, sir.
So you have to figure out how to get that. That's your business. You got to carry around like a driver's license. And then your driver's license, was it your driver's license that was an issue too?
I've been trying to get a Texas one, but every time I go down there to the place, they say they need 3 and 4 proofs of identification. And one of my wallets got stolen with my social security card.
And you can't operate a motor vehicle on my watch. Again, if you're operating a motor vehicle without a driver's license, a valid driver's license, that's a crime. That's condition 1 of your bond. You got to follow the rules, like we all have to. I got to follow the rules too, but I'll be darned if I'm going to follow them and you're not. Everybody's in the boat together. That's the law.
Mr. Thomas, do you have a Louisiana driver's license?
Yeah, that's what I was telling him. I didn't want to get no trouble. That's why.
Okay.
Where is it?
It's in the red car at Neil. I was supposed to go there the day after the car just got towed.
And after that wreck,
yes, sir.
Okay.
Okay.
You're ordered to come back tomorrow with the information.
Yes,
you
sir.
don't come back tomorrow with the information, your bond will be revoked. A warrant will be issued for your arrest on these 2 cases. And you need to be back here and you have to produce a valid driver's license. Do you understand? Yeah, sir. You're supposed to have it on you and you don't. You can say that. They law. I could say that, yeah. Oh, I've got one. It's in Alaska. Well, good. Thank you. That helps. That's verification. Or on Mars, something like that. Just, it needs to be in your possession if you're gonna operate a motor vehicle.
Yes, sir.
Period. All right, that is, we'll see you back tomorrow on.
Tomorrow. So now.
Okay, what else? MTRP with Willie Coward. All right, is Mr. Coward?
He's in custody.
Judge, you need to get some information about this guy.
Which guy?
Coward. This is the individual that more or less went to TDC. Basically told his supervising officer with probation that he didn't want to report, that he had credit for his time and wasn't going to report. So once he was released from TDC, the first month that he did not report is when this revocation, right, so that's when this revocation was filed. The problem is that there is a restitution owed, about $4,000 something dollars. And so we don't, either way, we're going to have to, cut a loss somewhere, I think is our problem in this case.
Okay. Ready to go on this?
Yes, sir. And I would ask, since we have the probation officer.
Hold on, let's call the case. 18-30013 is called the State of Texas versus Willie Franklin Coward Jr. Is that you?
Yes.
Present with Mr. Grove, your attorney and the state's attorney. Now, there is before the court a motion to revoke probation. It was filed August 11th, 2023. Actually going on 2 years. And does the defendant waive a formal reading of this? Can we proceed in summary?
Yes, Your Honor.
Okay. And raise your right hand, sir. Do you solemnly swear or affirm any statement you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay. In summary, this indictment states that on September 9th, 2019, you were sentenced to 10 years in this court, and that was probated for 10 years for the state jail felony of theft. There must have been prior convictions that elevated it to a
yes,
pleaded true to paragraphs.
It was the amount, I believe.
1 and 2. So 1 and 2, 2012. Okay. So it was the punishment was enhanced to 3rd degree felony punishment because those were 2 prior convictions on the same day. And it was a state jail felony, but it's punished as though it were a 3rd degree felony because of your prior convictions in paragraphs 1 and 2 of I'm sorry, paragraphs 2 and 3 of the indictment. And then allegation 1 states you failed to report to the Jefferson County Probation Office on or about April 6, 2023 in violation of condition 4 of your probation order, which says you must report timely. And number 2 alleges in the motion that you failed to report to the probation office on or about April 27 in violation of your probation order. And how do you plead to those allegations 1 and 2, failing to report as required, true or untrue?
It's true, Your Honor.
Or is it true?
Yes, sir.
Wait. I guess.
I've been in prison, Your Honor. I was trying to give you this from the last time I was here.
Yeah, we need everybody present to deal with that, and the probation office. Everybody needs to be dealing with this. Since you were sentenced to prison in 2019, were you ever released?
Yes.
You've been in prison since 2019? You're under oath. You're under oath, sir.
1 month I was out, little better than a month.
Which month was that?
Your Honor, Mr. Coward was paroled April 6th of 2023. He was sent a letter correspondence to his last known address at that time in which.
Were you paroled on that in April of 2023? So you were released from prison?
Yes.
And for how long were you released?
What were you released? I sit through the half.
How long were you
I don't know.
Your Honor.
A year?
No, it was a month.
1 month? 2 months?
About a month and a half, 2 months.
About a month and a half, and it was in April?
I went to see my family and went to turn myself in.
Okay, what you required to, condition 4 is, say, of your probation order. Okay.
Judge, I'm not.
Hold on, David, let me get to something here so we can put it on the record. This was a cap of 4 years on the deal. You could have been sentenced to 4 years in prison, but I gave you a opportunity for probation on this. In spite of what I'm looking at, you're 1, 2, 3, 4-page criminal history and the public safety report that the court is reviewing. In the file here. All right, report is directed by your probation officer and obey all rules and regulations of the Jefferson County Probation Office. And I guess the probation officer who's here will support that when you were released, you were you had to report, which was on or about April 27th, 2023. And
Your Honor, may I interject?
Yeah.
Your Honor, when Mr. Cowart was paroled on April 6th of 2023, he was paroled to a halfway house here in Beaumont.
Okay, hold on. How was he paroled? He was sentenced to 10 years in prison, probated for 10 years.
On a different case.
When he was placed on probation, he went from Jefferson County to Hardin County to Orange County to TDCJ.
Okay, 2 other jurisdictions dealt with him on cases, and then he was sentenced to prison on 2 other cases from 2 other jurisdictions.
Yes, sir.
But meanwhile, his probation was still pending and
Rolling.
valid here in Jefferson County for him to serve when he was released in prison from those other 2 cases.
Yes, sir.
Okay.
And at that point in time, after his probation, Mr. Cowart sent numerous correspondence to the court asking for revocation. However, we had no violations because he's been incarcerated.
Yeah, we got one now.
Yes, sir. And when I learned of his parole, he was sent a letter on April the 10th, which prompted a telephone call. I'm sorry, April 10th of 2023.
Yeah.
It prompted a telephone call from Mr. Cowart on April 25th of 2023, in which he informed me he had no intention to comply with probation nor parole. And we discussed the fact that we had no violations, and he advised that he would not show up. Therefore, we set an administrative hearing. I advised him of the hearing over the phone.
And that was 2 days later?
Yes, sir. It was set for April 27th of 2023. He failed to appear for that hearing. The hearing was sent to the court and the motion was filed. He was arrested on April the 3rd of 2023 on a parole violation.
Hold on.
Which sent him back to TDCJ.
April 3rd?
Are you sure?
I'm sorry, May 3rd.
Oh, okay.
I'm sorry, my apologies. He was arrested May 3rd of 2023 on his parole violation.
It looks like the week after
Yes, sir.
the 27th that he was to report.
Yes, sir.
And so is that why he had a bench warrant to get him here for these hearings?
I don't know. That's 23. This is 25. Where have you been from?
He's been incarcerated
On
That
which
makes
charge?
sense.
Those ones out of
on the
out of
paroles.
other districts?
Yes, sir.
But that was a retainer on me from February.
Yeah, now that makes sense, Judge, because I think one issue that was raised in the last time we were here was that
77 days, correct?
right, that he was brought here on a bench warrant, which didn't track with him, not reporting and being able to actually report like he
No,
was
it's-
supposed to.
it's-
But now that makes
makes through Jeannie's evidence in her discussions with the defendant.
right. But I'm saying last time we were confused about whether
Yeah.
or not he had ever been released,
Okay.
or how long he had been. So now
So-
that makes sense.
From probation's calculations, how long had he been a free man, released from prison and was out
April.
and about?
April 6th of 2023 until May 3rd of 2023, roughly
Almost a month.
almost a month, 30 days, 27 days.
And he has 270 something days credit.
70.
Yeah, in 2019, when I went in front of the Orange County judge, I talked to my lawyer, asked him to sentence me to 5 years. I asked him, I said,
Wait, that, and I'm sure that's an interesting story, but I don't think it has anything to do with me.
I know.
In this case, that's all we're worried about, is
Yes.
what would that have to do with this?
What Judge Stevens,
I asked my
Yeah,
lawyer-
that's something with y'all and, what is it about this case that I put you on probation for and the terms of probation that you were supposed to follow that allegedly you failed to do? That's all that's relevant. How much is restitution on this?
Your Honor, the restitution amount is $4,280.12.
And it goes to whom? The complainant.
We were just talking about that. It's not an insurance company. It's a.
What was the circumstances?
I have the PSI report, Your Honor.
Let me see. I'm looking, I've got it.
Oh.
County Home and Outdoors in Needham.
It's a business, I believe Mrs. Law said, out close by the jail.
It says Coward and McDaniel admitted they were responsible for taking those items.
I don't think he's ever had a problem with admitting his responsibility, but making amends for it is a whole nother
Are
story.
you clear from those other districts right now? Have you finished serving those sentences? Yes. Go ahead.
Judge, basically, as I understand it, besides the possible 1 month or so that he has been out under some terms, he's been incarcerated since he was placed on probation back in 2019. And he's been in the whole time. Now, one of the things in past conversations, and I did not get brought into this until relatively recently. And in fact, because we were talking about 2019, that was after 7 years. The file that I had from back when I represented him back in 2018 and 2019 was destroyed.
The
Because I saw
dog
no
didn't
reason
eat
to
your
keep it.
homework.
What?
The dog didn't eat your homework.
No, sir, it was destroyed because it was 7 years and I under
Well, we
both
can put all
things.
that together.
But anyway, so trying to reconstruct this has been difficult. I think Ms. LeBlanc understands it because she's had to deal
Well,
with it.
it seems clear now. After listening to her, we know where we are on things. My feeling here in Impulse is to get him going on probation so he can active probation to complete this thing so he can get the people paid back who I'm sensitive about victims. And there's $4,000+ here of loss.
The only problem with that, Judge, is that he's made it very clear with Ms. LeBlanc that he has no intention of doing probation.
Okay, well.
If
well,
that's
but
not
I-
true, then
If that's true, then it would be easy. It would be easy and we wouldn't be wasting a lot of time, but my impulse is to give him a chance to help fix this for once in his life and be successful on something here, pay these people back who are owed and move on with his life and do better.
Well, Judge,
But everybody has free will and that's where we're going to be, Mr. Coward. We're going to ask you.
yeah, as I
For
say,
you to be able to, you're going to be under oath here, or if you say, I refuse to follow the terms and conditions of probation, which include restitution, it'll make it real simple today and it'll be cut and dry, but I'm giving you a chance to take the honorable route.
Judge, there may be some other factors that might be mitigating. Do you have any medical conditions that keep you
Let's
from
swear.
being at work?
Yes, I've got a plate with 6 screws in my neck.
Okay, we're going to raise your right hand. You solemnly swear or affirm that the statements you make during this hearing will be the truth, the whole truth, and nothing but the truth. So help you God. Lower your hand.
All right, now I know that we could make this go on for hours, but
we don't.
But to be rather and to get to
When
the
did you
point, what are your problems?
Yeah. Well,
What are your medical problems?
My medical problems, I wrote this out. I got a plate and 6 screws in my neck. I fell 20 feet head first on concrete.
When?
Hurricane Ike, was at Nederland Apostolic Church working and fell off the scaffold. Got a plate and 6 screws in my neck. I got a rod plate and 7 screws in my left arm. I got a lumbar on the side of my shoes and L4, L5, S1. I have 7 pins in my right foot. I got stabbed in prison in my left eye with a key. I got mental issues that I don't even know. I've asked them since 1999 what's going on with me. The last time I was here, I had like a spell. They say it's Asperger's. I don't know. They said it's conversion disorder. I don't know. Another one was I took a psychology class just to find out what's wrong with me. You know, and I got a certificate on Adobo that they just started in prison last year. I feel like it's an epinephrine mixture that's gone awry or something because it happens all
Is
the
that
time.
your medical diagnosis of your extensive training?
Basically, yeah.
Well, while you got these diagnoses, though, you got those from the Texas Department of Criminal Justice while you were incarcerated.
Right.
It's not like you were out seeing a doctor at a hospital or something like that. It was while you were incarcerated. And these are the things during the regular course of treating you as an inmate that you saw these medical people.
Yes, sir. I explained my symptoms and just was what they said it was Asperger's, but it would take a while to get a definitive diagnosis. My nerve pain in my right leg and you don't go down my foot of my butt cheek. I don't know what it is, but I can't stand up very long, so it's killing me right now. But as far as working, I couldn't honestly tell you that I could go out and make that kind of money and live, you know.
Well, I think you can. I've lived long enough to know that people don't have to be able to ambulate extensively to earn a living, a very good living. Your cases in the other districts, what were those? In Orange County and Hardin County, is that right? What were those? Because that's not in your motion to revoke probation. I don't have that. Nor do I have that in the indictment. I don't think, unless it's.
Your Honor, I believe they may have been
I think he's right. He was
here it is.
he was required to register, and then he had from a 1991 sexual assault of a child. Then he had a registration in Hardin County.
Oh, okay.
Is that right?
I believe, yes, sir.
Okay, that's what you were in prison for here
Yeah, I guess.
after this case was, I guess,
Yes.
disposed of. What about, was that in Hardin or Orange?
Hardin was,
What was Hardin County?
like, light drive ticket, failure to
You don't go to prison for failing to pay a
Actually, I
ticket.
didn't go to prison for pardon, felon, I just got time served.
I think he's describing a misdemeanor and the registration offense must have been out of Orange.
Okay, well, you're, whether you like it or not, what I want to do is get these people paid back, and you haven't told me anything that impresses me about a problem that would render you unable to make an income, sir, except your unwillingness to work. There are people who have far greater issues than yours that are self-sufficient, who do fine. It's just a matter of you wanting to do something which is different from your rich criminal history, which includes 1, 2, 3, 4, 5 prior convictions for credit or debit card abuse, where you misuse those kinds of things. And then this case that you were placed on probation for theft. You're not going to flim flam me. Your life has been a series of dishonest crimes. You're going to go out and do something we all ought to do, and that is work. Be self-sufficient. Quit whining about problems that aren't serious. Everybody's got issues. None of us are perfect. We nonetheless work with them and around them because we have a desire to be self-sufficient. If you don't want to work, you tell me. We can end this one really quick and we can send you back, which would be a result of sending you back to prison. Yeah, but I want to give you a chance and the victim to get some money back so you can do something that you haven't done in a long time, and that's act with responsibility and pay somebody back for the harm you caused. You see anything wrong with that plan? Don't look at him. I'm talking to you. You're the defendant. You see anything wrong with that plan? You just don't have a desire to do the right thing, do you? At the end of the day, you don't want to do the right thing, do you?
I've done 6 years in prison for this.
No, you still owe somebody a loss, sir.
This is like stacking my sentences, ain't it?
Did you read that in the books too? That's not what it is. Restitution is a separate of the justice
So it's just
system.
about money then?
It's somebody else's loss. How do you fix that for somebody?
You
You got to pay them back. Do you think that person who's out $4,000 feels, oh, I've been paid back since he stayed in prison? That's not the way it works, sir. But you've been in prison for other crimes, not this one. This is, you were placed on probation. Now, we can figure a way where if that's what you want, to go to prison to serve this one, but you hadn't been given prison for that. You're getting credit for time you have served in conjunction with this case, but it's 277 days. You've served your prison sentence for Hardin County and Orange County. You haven't served your prison sentence in this because you haven't been placed in prison yet. You've been on probation. Now, the question is, what do we do here on this case? There are these two cases that we can move forward on. Are we ready to proceed on these failures to report allegations?
No, I filed my last one of those.
Well, then you can represent yourself.
Judge, if I could just have less than a minute. You believe that you have served 2 years in the Texas Department of Criminal Justice, day for day, on this case that's in front of Judge Stevens. Is that correct?
He hadn't been revoked yet. He's on probation. But he'll get credit for time served.
What he's trying to communicate, not the fact that he
doesn't decide whether that's satisfied.
No, sir, but
the law says you served 10 years. It's up to the parole people to decide how much of that you are rewarded. But you're still on probation. You haven't been revoked. You have been You have credit for 277 days, but that's not 3,650 days, which is 10 years.
We'll have to do a 4-year count. What is going on here, man?
You were sentenced to 10 years in prison, probated for 10 years. Isn't that correct, sir?
No, with 4-year count.
Sir, you were sentenced to 10 years in prison, probated for 10, correct, sir? Okay.
No, with a 4-year count.
Anything else?
In other words, what you're trying to tell me, so I understand this, is that you felt that your sentence should be limited to that 4 years because that's what the cap was.
That's why I signed it. And I was going to prison in 2019, I was sentenced to 10-year probation or a prison term not to exceed 4 years for theft of property. In 2025, you, Judge Stephen, said that since I wasn't never reported, I wasn't properly on probation. So I don't understand why I'm even being revoked. Went for an Orange County judge. Neither of y'all ran my sentences consecutively. I was not
David, here, hold on. Right here. All right, right here. There's the judgment in this case. There's the judgment. This is the lawful order, right where my finger is. See that? David, give it to him. Tell him what the judgment says.
I think the judge is talking 10 years, institutional provision of TDC judge.
That's the judgment in this case.
When was I told?
On the day of the hearing, you were told that. The court reporter takes the notes and the clerk takes whatever I say in the record. Nothing else will they use except what's on the record in the proceedings. And everybody was here knows that. So you can't deny it. This is what
The 4-year count. Y'all
And
know that.
Judge, the
That
4 year,
years,
right.
if you were sent to prison flat, that's what it means, and that's what everybody understands. I placed you though on probation, which allows me to sentence you to a higher term, but suspend so you can do probation. You can't say, okay, the limit was 4 years flat time for you to be sentenced to prison. But that's not what I did. I gave you a chance to be a free man, do the right thing and pay these people back who were victimized. In spite of your intent to avoid being responsible for paying people back and being answerable to this crime. That's what happened when you failed on this. See, true. Yeah. You pleaded true to paragraphs 1, 2, and 3, which gave you a 3rd-degree felony of punishment up to 10 years in prison. I could have sentenced you to 4 years flat time, but I didn't. I placed you on probation for 10 years, which meant you are looking at up to 10 years if you fail probation. But here's your chance to just go out and be a free man and do the right thing and pay these people back. I'm asking you to think about doing that. It's the right thing to do. And you're free. It's good for your soul to pay the people back the loss. It's a win-win all the way around.
In other words, he would be out. He
Yes.
would not have to be in jail. He could be out. Is, I believe, what the judge is trying to.
You're a free man, except you owe a loss to these people of $4,000, which you didn't pay back by serving prison time. They don't have the $4,000. That's how you fix when you take money from somebody or value, you pay them back. They don't get anything in return by you going to prison. That's not just
How
for
long
them.
do I have to pay them back? I mean,
10 years. Well, you pay back what you can.
yes.
In what way you can. But you have to try an honest try to do it.
I will agree to that, man. I have no problem. I know I will.
Okay.
All right, Miss Winters, go ahead and start your video, please. Thank you. Go ahead and unmute your device, Miss Winters. Thank you. This is in the matter of the people of the state of Michigan versus Jennifer LaShawn Winters, file number 25-22201FH. I have Isaac Sneed appearing on behalf of the people and Katerina Dumont appearing on behalf of Miss Winters. Says the date and time scheduled for a pretrial conference. Miss Dumont, just for your information, Mr. Malaro adjourned Mr. Winters for a pretrial on July 9 at 8:30 in the morning. How would you like to proceed today?
Your Honor, this is a global plea resolution between Mr. and Mrs. Winters, so we would just like to follow along with Mr. Winters' case. We are at the mercy of their plea to get ours dismissed.
All right, so I will adjourn this as well to July 9 at 8:30 in the morning. And can you do the step in order to adjourn?
Yes, Your Honor.
All right, thank you, Miss Winters. You have a good day.
Thank you.
Cleared out my courtroom, Mr. Hartung. All right, let's see. I have
I have no probation intake.
You do not have it today.
Okay.
His paper is here. Oh, he's.
Oh, here it is.
Ashley Lonnie for the people in the Artuso matter.
Court does call the case People versus Artuso. All three cases.
Assistant Public Defender Natalie Pate with on behalf of Mr. Artuso and the cases ending in 1656 and 1657.
Good morning, Your Honor. May it please the Honorable Court, David Burgess on behalf of Rick Artuso. It's the remaining matter set for pretrial, Judge. Okay. Your name, sir? Rick Artuso. Thank you. All right, what are we doing?
Your defendant is set on Tuesday for a preliminary exam in a different case that involves the same victim as the larceny case in this case. So the people and defense are requesting to adjourn this matter to allow the preliminary examination to go first.
All right, and that's on your case. That's correct, Your Honor. I represent him on both on the other matters as well, but that's correct. Judge. So that one I will adjourn to June 18th.
Yes.
2025, 9 a.m. Bond will continue in that matter. Thank you. All right.
And I would also request an adjournment as to these two matters, Your Honor. This is a ticket case that I've been in discussions with the people about, as well as my client. I don't know if we'd be able to resolve it by the 18th. There's a world in which we could, but I would not be opposed to a later date.
Okay, I'll see you.
That's correct, Your Honor. And Ms. Payton and I have been trying to work on to it. This may be one case that ended up in, just maybe one ticket that ended up in two cases, and maybe the same ticket just got duplicated somehow. So we're working on that as well.
Oh, where he was written for two things on the same ticket.
Where he was written one ticket, or it was entered twice, or two things on the same ticket. I can't recall off the top of my head right now, but I do believe it may one of this.
I believe that it was a duplicate case. I think it was just entered twice. But
no, you mean 1657 and 1656?
Yes.
No, there's so you don't have a copy of the ticket.
We do, and we have the same discovery that we've been provided by.
So the ticket was written for two charges.
Correct.
And they're just in two cases. So
they're both, well, the discovery I have is they're both charged twice on each case. But regardless, I have been discussing.
So you have it, so I don't, what do you have? Hold on.
I have that both cases are charged for DWLS and operating unregistered vehicle.
I don't know where you're picking that up from. When I'm looking at the JAS printout, the card stock in the case and everything else, I have 1656 as a DWLS, which is the first charge on that ticket.
Mhm.
And then 1657 is the no insurance.
Oh, I see. Thank you. Okay, thank you. That's probably
Okay,
correct.
So
yes.
they're not duplicated. They just come out of the same ticket.
Thank you, Your Honor. Very helpful.
So are you looking to try to have him potentially in a position of clearing his, I mean, how much time?
Potentially, my client thought he did have a valid license. Was able to run his driving record on my end. I show that it's currently suspended.
He's right.
Oh.
Yeah, he has a valid license.
That's great.
Yeah. So let me just make sure when that was run. As we received our response, SOS response on May 28th, just a few days ago.
Okay.
And his NCL he's valid.
Perfect.
He's got a
He
valid.
was right. I believed him. I must have run it incorrectly or entered the wrong date of birth from
Okay.
Mr.
So he's got a valid license. I don't know if that helps.
Your Honor, the people would offer if there is a plea to the unregistered vehicle, we would just disregard
The other ticket. So if he pleads to 1657.
Yes. Thank you, Your Honor, and thank you, Ms. Lundy.
All right. So what does he want to do? Do you want me to adjourn it?
I would ask for a brief adjournment to discuss this with him again.
So I'll adjourn both cases out then to the 18th, 9 a.m. and hopefully we'll be able to get it resolved then.
Thank you, Your Honor.
All right. Thank you.
Thank you, Your
Fine,
Honor.
continue. That's called the case of the people versus Justin Goltowski.
Ashley Lana for the people. Assistant Public Defender Natalie Pate with and on behalf of Mr. Giltowski, who should be present via Zoom. Sir, can you please unmute and state your name for the record?
Justin Goltowski.
Thank you, Your Honor. So Mr. Giltowski has left me several emails and I've left him several voicemails. That being said, we have missed each other on all of those communications. I'd respectfully request a brief adjournment so I can discuss what he would like to do with this case and next steps.
June 18th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor. Thank you, Mr. Giltowski. You're all set for today. We'll make
Thank you.
contact successfully before next time.
Okay, thank you.
Why is Parity against the wall?
I think she just moved out of the way for the last.
Oh.
Defendant. Manners.
Because she has manners. Court calls the cases of the people versus Vincent Dunlap.
Ashley for the people.
Conrad Siller on behalf of Mr. Township.
Good morning. Assistant Public Defender Lauren Perny on behalf of Mr. Dunlap.
And good morning, Your Honor. If it please this honorable court, Brandon Bird, also on behalf of Vincent Dunlap. Mr. Dunlap, can you please state your full name for the record?
Vincent Edward Dunlap.
Thank you. All right, what are we doing?
Your Honor, we did all have a conversation with all relevant parties in these matters. I believe Mr. Bird and I are requesting adjournments on the 3 files. Mr. Dunlap has a felony that's before Your Honor tomorrow. And the resolutions on these files may follow what happens on that felony sheet.
Gotcha. So would the 18th be enough time, we think, or?
I'd ask for one more just in case.
What's after the 18th?
July 2nd.
All right. I'll adjourn all of these then to July 2nd, 2025, 9 a.m. He does have minimal bonds on. Yeah, he has $100 bonds on all of these, so. All right, thank you.
Thank you.
Thank you. I wasn't about to argue this time, yeah.
What?
I wasn't about to argue mine this time.
Were you? Oh, no, go ahead.
No. I was. Thank you, Your Honor, for the court.
All right, take care of yourself, sir. Let's call the case of the people versus Christopher Holt.
Ashley Lundy for the people. Good afternoon, Mr. Public Defender Warren Perry on behalf of Mr. Holt. Mr. Holt, please state your name for the record.
Christopher Holt. Thank you, sir. Yep.
Yeah, we have come to a resolution. Mr. Holt would like to plead no contest. I will admit my faults, when they exist. I did provide the court with a police report last night, which I know is over the deadline. I did speak with Mr. Holt regarding the possibility of a adjournment. However, we are prepared to report this police today, depending on,
Yes, my staff let me know that you sent it late, but I took the time this parent last night to go over the police report.
thank you, Your Honor. I appreciate that.
There'll be no more favors.
Fair enough.
All right. Okay. What's going to be the plea?
So he's going to plead to an added count of larceny under $200 in exchange for a dismissal of count one. That's correct, Your Honor.
That's a no contest plea.
Yes.
Sir, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God? Yes, sir. State your name, please. Christopher Holt. All right, you can put your hand down. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of larceny under $200. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that? Yes, sir. All right. Do you understand what a no contest plea is? Yes, I do. All right. 2 things about it I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. You understand that? Yes, Your Honor. Second thing you need to understand is that for purposes of sentencing, the court's going to treat you the same as though you had pled guilty to the charge. You understand that? Yes, Your Honor. All right. So understanding all of that and the basis for the no contest plea.
That's just civil liability, Your Honor.
All right. So, sir, understanding all of that to the charge of larceny under 200, how do you plead? Plead no contest. All right. Now you understand that by pleading no contest, you will not have a trial of any kind. Yes, Your Honor. You signed an advice of rights form. Is that correct? Yep. Any questions regarding any of those rights? No, Your Honor. Under paragraph 5, those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form. Yes, Your Honor. You understand you're giving up your right to appeal of right? Yes. Are you on probation or parole? No, I'm not. Has anybody promised you anything other than what's been stated here today to get you to plead? Nope. Anybody threaten you or coerce you? Nope. You're doing this voluntarily? Yes, sir. And of your own free will? Yes. All right. As indicated, the court has been provided, albeit late, Pittsfield Township Department of Public Safety report for their case number 252506. Any objection to the court having reviewed that report?
No, Your Honor. No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
People are satisfied. Satisfied, Judge.
All right, court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Defendant is referred to probation for pre-sentence investigation and report. Sentencing in this matter will be June 25th, 2025, 9 a.m. Bond will continue. All right, I don't have probation intake on the screen, so you'll have to call over and make an appointment with our probation department. Okay, sir? Yes, Your Honor. All right, thank you. Thank you. You have a good day. You too. Bye. Court calls the case, People versus Jacqueline Murray.
Conrad Silver on behalf of Pittsfield Township.
And Ashley Lundy for the people.
Assistant Public Defender Natalie Tate, with and on behalf of Ms. Murray on the case ending in 1190.
And Kyle Goodell on behalf of Miss Murray in the two other matters.
Hey, what are we doing?
Mine might be the quickest one, Your Honor. I have discussed this matter with my client as well as Mr. Siller. On my case ending in 1190, I'm respectfully requesting an adjournment of this case to potentially work out a global resolution with Mr. Siller. Miss Murray is being seen on her felony case tomorrow in front of Your Honor. So I would just ask for a couple weeks if possible.
That matter, I'll adjourn June 18th, 2025, 9 a.m. All right. Bond continued on that. All right, on the other matters.
Thank you, Your Honor. As to the matter ending in 1911360, retail fraud with the state, we will be adjourning that. We'll be requesting an adjournment on that matter.
Adjourn that matter June 18th, 2025, 9 a.m.
Thank you, Judge. And as to the matter ending in 191-1668, Prosecutor Siller has made an offer to plead to admit responsible to double parking. Ms. Murray would like to take that offer.
Count to double parking. If you accept that admission, move to dismiss the original charge.
All right. Let's count to. And Ms. Murray, do you admit responsibility to the fact that on September 23rd, 2019, Washtenaw Avenue in Pittsfield Township, that you double parked a motor vehicle?
Yes, I do.
All right, court will accept that admission to count two. Count one is dismissed. I'll do fines and costs of $180. I'm not going to put a time on it. At some point at the
Okay, thank you, Judge.
Thank you.
Thank you.
Court calls case People versus Khalid Hashara. Or Hashara, no, I'm sorry. They put this. Yeah, they just have it listed. Oh. Hashara Isa.
People. Assistant Public Defender Natalie Pate with and on behalf of Mr. Issa, who appears via Zoom. Sir, can you please unmute and state your name for the court?
Hushar Isa.
Thank you, sir.
Thank you, Your
pleasure,
Honor. I'm respectfully requesting an adjournment, if possible, 3 to 4 weeks. As of yesterday, our office did not yet have discovery in this case, so I'd ask for a possibly slightly longer adjournment so I can get it, review it with my client.
Retrial July 2nd, 2025, 9 a.m. Bond continued.
Thank you, Your Honor. Your Honor. Thank you,
Thank you,
Mr.
Mr.
Issa.
Thank you, Honor.
Court
Thank
calls-
you, Ms. Natalie.
Court calls the case People versus Devon Gibson.
People. Assistant Public Defender Natalie Pate with and on behalf of Mr. Gibson, who's approaching the podium. Please
Your
state your
name?
name for the record, sir.
Devin Gibson.
Thank you.
Thank you, Your Honor. I'm respectfully requesting an adjournment. I have discussed this case both with my client and the people. The media that my office received, the media discovery that my office received for this case is for the incorrect case. So we just need to get the correct media and review it with Mr. Gibson. I will say for the court that he is being held on some felony matters with his next court date being July 14th. So we have no objection to a lengthier adjournment so that we can make sure we have the discovery by then. That's correct, Your Honor.
July 2nd, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Well, hold on. What's his bond? Okay, he does have a
He
small
should.
cash bond, so he's getting credit.
Thank you, Your Honor. Thank you, sir.
Court calls the case People versus Kenneth Miller.
People.
Kenneth Miller. This is an arraignment. Failed to appear, order to show cause.
Hello.
Court does call the case People versus Stephen Grisbeck.
Conrad Silver on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Grisbeck. Mr. Grisbeck, please state your name for the record.
Stephen Grisbeck. Thank you.
Your Honor, we are here for a pretrial on the possession of drug paraphernalia case. I did speak with Mr. Grisbeck. He would, however, like me to renew his request to be released on his domestic violence case.
I don't have the file before me, so I'm not gonna hear that, and I don't know that the prosecutor assigned to that case is here, so I'm not.
That was the one with Miss Polara.
Pardon?
That when I was here 2 weeks ago.
I know, but I don't have, I'd have to hear from the people regarding that, and that's a domestic violence case, and I don't have the domestic violence prosecutor assigned to the court. So
I can get in touch with Ms. Zenda and Ms. Polara again. He has completed more classes and wanted the court to know that.
and that was so that you know, and I mean, I don't really want to address it here, but that information as to the classes was provided to the court. And I did look at that earlier this week. I think it might have been Monday, or today's Wednesday. So it was Monday that they provided that information to me, because the information had come from the jail requesting that. And so I don't know that I made a decision on that in any event. So
I did receive a decision from Ms. Polara. Again, we don't need to
you
get-
probably did.
I did from
Probably
Ms.
made a decision. I just don't recall specifically what it was, but I did review.
Yes, and you said he wouldn't release him at that time, so that's why he wanted me to readdress it. So
I'm just at stake of losing my housing, Your Honor, and
I took all of that into consideration. I also took into consideration, again, I didn't want to address it, shouldn't be addressing it because I don't have that file in front of me. But there were a certain number of classes that needed to be completed that had not happened at that point. And so I gave the preliminary answer that I did. Ms. Perny, certainly you can talk to Ms. Polara and Ms. Zenda and see what can be arranged that might be satisfactory for everyone.
yes, Your Honor, thank you. As for this case, we are requesting an adjournment. We're doing a little bit of investigation. That DV case is holding him. I don't think this one is, so we're just requesting another date.
Pre-trial June 18th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you. Council approach on that matter.
Hi, I'm so sorry to interrupt. Did you guys call Michael McMullen already?
Calls the case. All right. Apparently, Ms. Miller has been transported to the hospital. There's a medical emergency, and Dawn Farm sent over an email indicating that she can't appear this morning.
Okay. I am
So-
sorry to hear that, but I would request an adjournment. given
I'll
that.
adjourn it to the 18th, 2025.
Thank you very much, Your Honor.
Thank you.
Hi, I'm so
Let's call
sorry
the
to
case of
interrupt. Did
People
you guys
versus-
call Michael McMullen yet?
Court calls the case, People versus Chad Jones.
Conrad Siller on behalf of Seal Township.
And that's the one for the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Jones. Mr. Jones, please state your name for the record.
Chad Jones.
Thank you.
Your Honor, we are requesting an adjournment of these two cases. Mr. Jones has three cases in front of Your Honor tomorrow, as well as some cases in 15th as well as the case before Your Honor scheduled on the 18th. So he's got some moving parts, so we're hoping to possibly do it
So
global.
he has another case before me on the 18th.
Yes,
Okay.
yes.
And let's try to get all of them together. Is that a state or Pittsfield case? Do you know?
It's a state.
State case. So I'll adjourn these to June 18th, 2025, 9 a.m.
Thank you.
Tag along with those.
Thanks, Your Honor.
Court calls case People versus Jared Roberson.
Eshalani for the people.
Assistant Public Defender Natalie Pate on behalf of Mr. Roberson, who should be present via Zoom. Sir, can you
He was. Mr. Roberson? Mr. Roberson, can you state your name, please? Oh, you muted. You'll have to, there you go. Mr. Roberson, can you talk to me? State your name. I think if you just talk now, Mr. Roberson, you just unmuted. I'm muting and muting, and so I don't know. What were we gonna do anyway?
I was going to be requesting an adjournment, Your Honor. The people did extend an offer in this case that would require Mr. Roberson to get a license in order to take advantage of, and he believes he'll be able to do that in July. So I'd request an adjournment into sometime then.
All right, you'll let him know. I'll adjourn this. We can't communicate with him, so you'll have to call him, but I'll adjourn it to July 16th, 2025, 9 a.m. I know he's here because he spoke up previously.
Thank you, Your Honor. And I expect him to be here. And I do apologize for that July 16th.
Yes.
Thank you, Your Honor.
Court calls the case People versus Noor Kasham.
Conrad Siller on behalf of Pittsfield Township.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Kashan, who stands to my right. Please state your name for the record, sir.
We all know. All right. Good morning, sir. All right, what are we doing on his case?
Your Honor, there's a resolution in this matter. I've been able to discuss this with my client and get the documentation from his mother that Mr. Siller has extended the offer of double parking in this case.
That's correct, Your Honor. So I'm going to count to parking. If you accept that admission, move to dismiss the original charge.
Mr. Kasham, do you admit responsibility to the fact that on May 9th, 2024, Platte Road, Pittsfield Township, Washtenaw County, State of Michigan, that you double parked a motor vehicle?
Sir.
All right, court will accept that admission to count 2. Count 1 is dismissed. What else is holding him?
His anticipated release date is July 5th. I believe he's serving a sentence on a VOP.
Okay. So what I'll do is fines and cost of $180. Said July 5th?
Yes.
All right, I'll make this payable by September 5th, 2025. All right, take care of yourself. Fit for that block? All right. Step off. We'll get set up for 11 o'clock and I'll come back out. Court's in recess.
All right.
Please.